plenary speaker. Inbal was a student of Tim Roughgarden and is now at the Technion. And I'm really excited to hear about algorithm design and the law.
Thanks very much. So I'm really glad that my talk is following yesterday's half-baked ideas session. I think it can be kind of viewed as extended pitch in that session, and I'm really looking forward to hearing your thoughts. One word about my background. So I'm a theoretical computer scientist, and this talk might be kind of biased, is probably going to be kind of biased towards that perspective. I do have a legal background, an undergraduate degree in law, and 1 year of kind of experience practicing law many years ago. Still, I think that experience is kind of what makes me really enthusiastic about this potential collaboration between the fields. So this talk is based on ongoing discussions with a bunch of people, Joseph, Niva, Michal, Shafi, Noam, Ariel, the organizers of this workshop, and many others. Of course, any errors are my own. Okay, so the main question I want to talk about today is, could there be such an academic research area as algorithm design and law? Okay, and specifically focusing on algorithm design and not CS in general. So you can see in this picture kind of one of the classic textbooks of algorithm design. The reason for this focus is, first of all, to make the discussion manageable and not, too high level that we can't really say anything concrete. And second, that I think there's untapped potential here, and this is something I hope to convince you of during the talk, or let's see what you think. Okay, so the starting point is that, as we all know, technological developments can serve as triggers for new fields of study. And I want to start with a couple of examples. Here are two examples from within the discipline of law. So the development of the legal right to privacy, to my understanding, followed technological developments like photography, like recording sound, and like the widespread circulation of newspapers. This was 130 years ago, so there's a lot of, many decades here of legal thought that hopefully as computer scientists we can tap into. Another example, more recent one, is cyberspace, the internet, triggering the need to consider code and its regulatory role. So work of Lawrence Lessig around 1999 on code is law. This is another example, mostly within law. Here's another example that's between two disciplines, computer science and economics. Algorithmic game theory is actually my main research area. So the technological development here was very similar to the previous example, the internet, more specifically online markets. So what happened is that computer scientists kind of found themselves engaging in market design, right? If you worked at Google and you were designing auctions for online advertising, you're basically doing microeconomic market design. And more generally, algorithm design in strategic environments. And this kind of created the need for guiding theory. And I'm bringing this example right at the start because I think this is an amazing example of hugely successful collaboration. So nowadays, this is my main research area, as I mentioned, and I interact daily with economists. My main venue for publication is Joint Conference on Economics and Computation called EC. So by the way, computer scientists, you probably know this, but the Target conferences is the main publication venue. And I'm kind of wondering if this could be like kind of blueprint that we can follow for law and algorithm design. I'll mention some caveats here. Okay, so we saw a few examples of technological development serving as triggers for new fields of study. And what's happening now is that usage of algorithms in society is basically exploding. Algorithms are infiltrating and governing to large extent almost every aspect of our life, both as individuals and as society. And I think one way to view differential privacy and fairness is as two research fields that arise out of this. Okay, so very briefly, kind of in the same language, the technological development that drove differential privacy can be seen as increasingly detailed electronic information about individuals, which created the need to define what it means for an algorithm to be private, and then come up with a bunch of algorithms that are actually fulfilling this definition. And exactly the same thing or very similar for fairness, increasingly accurate algorithmic predictions, which raise the need to mathematically define, rigorously define fairness, and hopefully have algorithms that satisfy these definitions. Okay, so with these examples in mind, we can take a step back and kind of more generally look at the technological development of algorithms having very far-reaching effects today on societal values, privacy, fairness, and more, as I hope to demonstrate. And then the new theory needs is theoretical guidance for algorithm designers who are basically engaging in social engineering that used to be within the realm of law. Okay, so to kind of recap the question, is it time for a wider academic collaboration on algorithm design and law, maybe in the same style of algorithmic game theory? And kind of the more specific questions we need to ask ourselves are, what would be the scope and content of such a collaboration, and what are the potential gains and challenges? Okay, so as I said, this talk is kind of initial ideas, initial thoughts. The goal is to facilitate a discussion, which I'm looking forward to. Viewpoint is kind of biased towards my own background, and I will try to not really talk about fairness and privacy, but rather about other examples. Okay, one thing I want to mention is that I'm not really going to be talking about what's sometimes referred to as computational law or AI in service of law. And this includes things like automated dispute resolution, legal reasoning, text mining, knowledge representation, e-government, and so on. So this is both to keep the discussion focused, also because these are areas that have already been addressed to a large extent. There are existing communities, dedicated conference like ISAIL, and so on. Okay, questions up till now? Good. Okay, so a little bit more motivation. Why is this the right time to have this discussion? I think both disciplines can have a lot to gain. So computer scientists, there's this huge body of literature and thought that we can tap into, like in privacy, for many other areas. And maybe what is the most motivating for us is new problems that we can kind of apply our tools and our way of thinking to. And this is, I think, maybe one of the main goals of this workshop, right? Surfacing new problems for us to address. Law, from the perspective of legal scholars, I think it's an opportunity to kind of expand existing legal doctrines and get inspiration from other approaches that are maybe more mathematical, more rigorous. And kind of more bluntly, I feel that each community really needs the other right now to stay relevant, right? Because we can, we can, have our definitions, mathematical definitions, but if they're not, if we want to actually apply them, they should follow. Algorithms need to be legal, first of all, and we don't want to miss this opportunity. And then on the other side, if de facto, algorithm designers are encoding legal doctrines, then this is where the action is happening. I think Omer put it much more nicely than I can. So here's a quote. Computer scientists cannot solve algorithmic fairness and any other issue of this sort on their own. These issues cannot be seriously considered without major involvement of computer scientists. And what we need is a true collaboration rather than kind of one community subcontracting for the other. Yes?
Sorry, I should have asked when you
no, please.
Of course, I want to bring myself and those of us who are not lawyers, neither computer scientists, into the discussion.
Yes.
And I want to just remark that law itself has to confront certain compromises in what it can and cannot address, or what it should or should not address, because it's subject to various constraints, like enforceability, for example. So I wonder if you wanted, and I'm looking at what Omer said, I don't see the word law in here. You're just saying we can't do all of this on our own. So it's fine. I think it's a good thing to look at law and computer science and see how the two can kind of collaborate and reinforce and so forth. But I also want to leave some room to say that the normative spade work also has to go beyond into the empirical social sciences and also maybe philosophical ethics.
Yes, I couldn't agree more. Yes.
You talked about all of these areas.
Yeah. Okay, I just.
And I think
That's
we're all
the
in
crux of
agreement.
some of my response.
Oh, sorry.
Preemption.
Yes, preemption. Okay. You can say it again.
Yeah, well, you said it in place. Then I'll just say, as Helen said.
But you need a nice picture of Helen.
Now, I think that maybe if we talk not about law but about norms, that would allow both the discussion of ethics and, law that is a type of regulating behavior by norms, as opposed to regulating behavior differently. Right?
Yeah,
Not
and-
necessarily by norms, right?
Although what I've learned, speaking to some of the computer scientists in this group even, is that the term norm itself, Kobe, is just highly problematic, but in our sense, yes.
Yes, I think there's a triangle here. There is what we want to implement is kind of normative standards that come from ethics and philosophy and social science, and we have tools for implementing them, and these tools are both legal tools and computational tools. And we need to understand the relationship between all these, the three interpretations. We need to make sure that the legal standards also match with the normative thinking about these topics, and they need to make sure that the computer science thinking matches that, and also that there's a match between the legal thinking and the computer science thinking.
Yeah, this is a longer conversation.
No, thanks so much for these comments. Yeah, no, I think we can expand also in the discussion, but I totally agree. Okay, here are kind of signs of tightening collaboration from the past year or so. There's going to be ACM event on computer science and law. This is happening in October in New York. The aims are particularly to bridge the divide between CS and law, to stimulate interest in this emerging field, to articulate a research agenda, and see how the ACM can be part of this. I put the topics on this slide in case people are curious. There's a bunch of things here within kind of computational law that I said I wouldn't talk about, but there are a bunch of things that seem highly relevant to this particular talk. Another kind of one of these signs is joint courses for law students and CS students. One of them happened last year jointly in Berkeley, Boston University, Columbia, and Harvard. And it was a little bit more focusing on maybe, I guess, crypto, verifiability proofs, and so on. But this also seems very relevant. There is the second year already Fat Star conference. This is, I presented there this year, and this is from the speaker instructions that we got that I found both amusing and very helpful. So we're very explicit about, computer scientists, please note that we're encouraging you to defer the technical details, okay? So I'm mentioning this because it seems to me maybe also kind of a warning sign a little bit. For example, when I compare this to the EC conference that I mentioned, there I'm very welcome to talk about the technical aspects of my work. Something to keep in mind. And then there are multiple additional events. I think Nicole will mention some in her comments, including, of course, this workshop. Okay. Now,
I just also mentioned the privacy tools project at Harvard that had also many components like that.
Right. Okay, thank you. So the comment was about the privacy tools project at Harvard.
So, just you mentioned there's a warning sign there, but EC is not it's a great venue, but it's not as interdisciplinary. Like the difference in perspective between mechanism designers and algorithm designers is like not that big. Right?
Yeah. Yes, I mean,
they still speak theorems and proofs.
Exactly.
Like
so
much less of a gap between them than there is between different kinds of economists, for example, or different kinds of computer scientists.
Right. I agree, and I think this is. On one hand, we kind of have to collaborate. This is my feeling. On the other hand, it's going to be hard.
Yeah,
so this is right. This is exactly it.
So I totally agree it's going to be hard, but I would change this suggestion to trying to find a language that will allow us to jointly work on the technical details.
Right.
And I think like avoiding showing the technical details to the lawyers or to the philosophers is not going to solve the problem. We will keep working in different disciplines without having a way to interact. We must find a way to communicate over the technical details.
Right, like maybe some of the similarity between mechanism designers and computer scientists these days is sort of hindsight of a 20-year-old field.
Yeah.
I tend to agree, but still, it's the basic language is math, which is.
So this is very interesting because I'm general co-chair of the next ACM FET in Barcelona. I'm going to take this home. I think that ACM FET is very focused on impact. So what's the impact of all these fantastic algorithm designs? And one of the things that is very important for this community is that these problems cannot all be solved by computational techniques. So the fear of having technological fixes and everybody presenting deeply interesting computational papers without showing why these technical details matter in terms of impact. So I think what I like is what you said, that the technical details may precisely be what makes that difference. Yeah, I'm going to take that home.
Yeah, and I would just say also that FatStar is in some sense trying to be a home for things that many people in this room and outside this room would say are not sufficiently technically novel for places like EC, for places like NeurIPS and ICML, where you aren't necessarily developing a brand new algorithm that beats some benchmark on some task, but saying something different about some system. And I think that that's something that computer scientists, especially theoretical computer scientists, but computer scientists in general, tend to not find, they say it's an observation as opposed to technical novelty.
But what if I'm greedy and I want both? I want both to,
Sure.
have the novel side. And... Okay, I'll take one more comment and go on. Yes.
It was going to be about Privacy Enhancing Technology Symposium, which is very interesting because it actually deliberately sometimes contests the law and talks about the shortcomings of the law, especially in the case of surveillance and government surveillance. So they are not interested in just normatively implementing law or being legal. In fact, sometimes it's like law will fail us, and how are we going to deal with that? And I think that's also important to see as another way of approaching the law. I'm not saying it's the only way, but like.
But then I have to also say that as a reviewer for the PAT conferences, the papers that I saw gave a complete misrepresentation of the law to such an extent that I actually said, look, don't ask me again, because the authors then respond to all the technical comments, and they say, as to my comment, oh, very good, we've inserted one sentence in paragraph 3. So this is a very big problem. First to misrepresent the law and then to say the law does everything wrong. That leaves us nowhere. So I do hope that ACM-FAT is not going into that line of thought, and I think it's a real challenge for all computer science conferences.
Okay, so here's a comparison between algorithm and legal doctrine. Okay, keep talking about algorithm design. I want to be a bit more specific about what I mean. Here's a picture of an algorithm. We have input and we have output. And then the algorithm is the computational steps that map the input to the output. There's going to be some objective, that we want to reach when we're mapping input to output, and constraints, both computational, which are the more classic thing we tend to take into account as algorithm designers. Okay, how many steps do I need to reach from input to output? What kind of memory do I need, and so on. And also these societal legal constraints that are more our focus right now. And just mentioned that algorithms may use learning, a big part of kind of what motivates this new area. Here's an example to make this more concrete. Self-driving car, self-driving policy. The input would be some data that the car senses, maybe what other cars are on the road, what's their speed, position, and so on. The output is the next action to take, maybe if you want to press the brake or not. The objective, well, there could be different objectives. Let's just for concreteness pick making progress along the route you want to take. And then the constraints are both these computational constraints of scalability, right? You want to be very you want to be able to drive in a road with a huge number of other cars. And then the more legal concern or societal concern is the safety of others. Okay, typically this might be learned through reinforcement learning and so on. Okay, so that was an example of an algorithm. Now, when I say algorithm design or as an academic field of research, what do I mean? So our main concern here is to find good algorithms or show that none exist for various computational tasks. And what do I mean by good algorithm? Another way to phrase this question is how do I compare between different algorithms and decide that one is better than the other? Let's consider, for example, two algorithms from this area of self-driving cars. Let's say that if you apply one of them, you get very quickly between two cities. If you apply the other one, you are doing a great job of driving within a big city while maintaining your constraints of scalability and safety. Which one of these is better? Okay, and the main kind of approach that we take to this question is called the worst case approach, meaning that we judge every algorithm by its worst case input. Okay, so if we have an algorithm that just does a great job within big cities, it's not enough for us because we want algorithms that are very robust. We want our self-driving cars to be able to get us anywhere, okay, like a human being would. Okay. Now, to complement the picture.
At the bottom that I wanted to hear, which is we're going to say about that.
Okay, thanks. There's this saying of hard cases make bad law.
What does that mean?
which is basically, so sometimes you have a legal doctrine that is working really well in almost all cases, but then that one case that gets to court has just circumstances that are unbelievable. You want to basically bend the rules to get to a result that anything else just seems unfair. And this is kind of referred to as hard cases make bad law, right? You want some sort of flexibility in the legal rule that will allow you to address circumstances that really are extreme, but you don't want to change the whole norm right now. I think Nicole will have more to say about this.
As a lawyer, I would not at all subscribe to this, because a lot of the development of the law comes from hard cases in being able to make a difference between a hard and an easy case is itself requires certain normativity that is very interesting and keeps law adaptive to new circumstances.
Right. Okay. I think we'll have more. Yeah, definitely have more to say here. I mean, there is something about this that you want to leave room for things that maybe you didn't foresee, whereas an algorithm is supposed to be robust to everything.
There's a difference between case law and
statutory law.
Yeah.
Right.
Also.
Okay, I'm definitely coming from the case law perspective. Okay. So let's compare to legal doctrine in the same kind of area of self-driving cars. A legal view of the same scenario could be that you have different drivers on the road. They all have a right to use the road. There are kind of competing values here. You want useful transportation on one hand. You want safety on the other hand. And what the legal doctrines will do is kind of balance between these competing rights and competing values. And here's an example of the negligence doctrine. This is really in a nutshell, and it might not be very precise, but just so we see an example. So the idea is that drivers should avoid being negligent, meaning not taking precautions that would cost less than the expected damages. And they should do so where there is a duty of care. Okay, so duty of care is kind of the open-ended place where we can balance these competing rights and values. Yes.
And does expected damages mean like expectation?
It does mean expectation. So there's a formula. There's almost a formula basically called the learned hand formula, which compares these two things. It is not very precise. I mean, what is expected damages, right?
So it takes into account probabilities.
It does take into account probabilities, but exactly. So you can be, narrow or wide, or so definitely. This is precise, but not not what you were used to in algorithm design. Okay.
I think a major difference between doctrines is that in algorithms we're kind of taking an ex-ante approach, whereas the law in many cases is taking an ex-post approach dealing with, and this is like one of the reasons there's a lot of uncertainty until actually things are taken into court and then there is a precedence, whereas we try not to get to the point where you have to go to court with algorithms.
Interesting. Okay. Yes.
I think that it's really important also to just put this in context of the institutions. When you're comparing the computer science and the legal approach in applying norms, what is really missing in this description of the law, especially when we talk about open-ended norms, is who is doing this, right? There is an institutional structure, like you mentioned before, right? This is sort of, and the institutional structure is inherent in this system. It's not a system that simply looks at two norms and try to figure them out, but there is an institution, legislature, courts. There are authorities, there are processes that are well defined, and this is how it is being made. So this is, I think that, and that is part of the, of understanding, what it means to regulate by norms and, like rules and open-ended norms.
Yeah.
Yeah, and maybe to add, the core of the rule of law is the fact that the entity that enacts the rule doesn't get to determine the interpretation. And it might seem that what would be more obvious and easy than to say, well, this is a democratic legislator, they decided to rule, so let them decide the interpretation, right? That sounds good. But like 300, 400, 500 years ago, we decided that that's a very bad idea because it leads to arbitrary rule. But it complicates this in an interesting way. So I would be very interested at some point to see how computer science would think about that. This idea that you write an algorithm and then you don't get to decide where it goes wrong and how it should be adapted, for instance.
Okay. So thanks so much for the interesting comments. I want to show 3 case studies, kind of bring the discussion more concrete examples of algorithms being shaped by legal doctrines and vice versa. I'm going to talk the most about the first case study because I think it's the most well studied, and then the other 2 mentioned more briefly. Okay. High level idea is, as we saw our example of self-driving algorithm. We had these constraints. One of them was safety. Should this constraint mathematically formulate the legal doctrine of negligence? And you can ask the same question for almost any algorithmic task that has implications to societal values. Okay, so here's some examples.
Can you clarify the question? Like, does it mean, should we try to interpret the negligence doctrine and then write that into the mathematical constraint
Right.
or algorithm, or do you mean the converse?
So I had what you were saying now in mind. What you were saying now, this is what I had in mind here, some examples. And the first 2 were things that you know, so I hope it will make it clearer. So we have, for example, data analysis affecting privacy. You can have a mathematical formulation and then mathematical formulation of the relevant legal doctrine. Okay, so it's not clear that this is actually what differential privacy is, but there is something going on in law, something going on in math. The algorithmic task can be subject to the mathematical formulation. Yes?
I don't see the legal doctrine of right to privacy, at least as I understand it used in the US, really having almost anything to do with differential privacy. Right to privacy is
that's
like,
a good, yes.
I can have sex with whoever I want and make sort of choices, medical choices behind closed doors, for example. And differential privacy is like Google, should, or my lender should do something with all its data so that it doesn't know too much about it.
Okay, so I mean, definitely this is not trying to describe reality, but there is a possible connection there. And should there be this gap, or maybe you want either the mathematical formulation or legal side or both to change and become closer. Same question for fairness. Okay, we want to predict something. Currently, there are multiple notions of fairness. There's definitely relevant doctrines in law. The 2 examples that I'm going to talk about right now are driving, safety, negligence, and an initial proposal for mathematical formulation. And another example of pricing, antitrust, free markets, and using formulation from economics. Niva talked about content moderation, which I think is another example that kind of, you can look at it in this way. Mathematical formulation, to my knowledge, is largely open. I think maybe because this has mostly been addressed in industry. But I think these are like interesting questions to follow up on. Yes?
I think one of the use cases you might play with is also something that Neva had raised, which is like the Digital Rights Millennium Act as an attempt to, represent, enforce be an alternative to legal regulation. Like that relationship is super interesting and worth maybe
Yes.
thinking through in this way. Because it's kind of mature.
Right. I agree. Yes, this is a good example.
There's also what's happening with Europe in terms of data privacy A and copyright B. The copyright one, as I understand it, is requiring companies to do automatic content filtering, automatic content copyright detection. So there, the law is requiring some sort of enforcement by algorithm, right? And also the GDPR, there's, I think the connection to differential privacy is maybe closer.
Okay. Okay, let me show the first case study. How much time do I have? Okay, I'll try to go over this quickly, but I want to see a concrete example. The paper I'm going to talk about is by Shalev Schwartz and et al. It's called On a Formal Model of Safe and Scalable Self-Driving Cars. The first and third authors are also the co-founders of, founders of Mobileye, which is a company that actually does right now self-driving cars. So what they propose here has actually been experimented on with real cars on the road, real self-driving cars, and it seems to work, making it very interesting. The main goal of their paper is to introduce a model that formalizes an interpretation of duty of care from tort law. Okay, this is a quote from their paper. They call it RSS, for responsibility-sensitive safety. It's designed to achieve the goals of compatibility with human interpretation of the law, usefulness, so not the driving shouldn't be too over-defensive, and then also tractable verification, which is interesting from a computational point of view. As one of the things that they want to achieve, they want that if all of the agents follow this policy, then there will be no accidents. Okay, so kind of what you would expect. Okay, they set out to formalize 5 common sense rules. Don't hit someone from behind, don't cut in recklessly, and so on. And I want to show you the simplest example of their model. Let's say we just have a single lane, straight road, and 2 cars driving forward. And let's see how they formulate the duty of care. So they have parameters. They have reasonable response time, maximum reasonable acceleration, maximum reasonable brake, minimum reasonable brake. And then they have a definition of safe distance, okay, for given velocities, given speeds of the 2 cars. Okay, and the definition is as follows. It's going to use the parameters. Let's assume that the yellow car brakes at a rate that is at most the maximum allowed one, maximum reasonable one. Let's say that the red car has some response time in which it might be accelerating at reasonable rate, okay, at maximum reasonable rate. After the response time, it starts to brake, okay, at the minimum reasonable rate. If all of this happens, the red is guaranteed not to hit the yellow if they have the safe distance between. Okay, any questions on the definition?
Just a small question. So this is an isolated picture that involves 2 cars on one lane,
Yes.
but the reality is, of course, very
Yes.
different. So does that feed into the definition somewhere, or?
What's amazing to me is that the same kind of definition generalized to, in the paper they show a lot of really complex other scenarios that basically the same definitions, when they're generalized appropriately, seem to work. And it actually work somehow in practice. Okay. So I have one definition of safe distance. I'm also going to define as proper response of the red car if once the safe distance, once the 2 cars are within the safe distance, and if the yellow one brakes, then the behavior is like it says here. So basically, maybe the response time you still accelerate, but right after that you brake at reasonable rate. Okay. The claim is that if the red car is properly responding to the first violation of safe distance, it's guaranteed not to hit the yellow car. Everything is under the assumption that these parameters are being are holding in practice. Okay, so that the yellow one is not braking too fast and so on. Okay, you can see that the way these definitions, this is maybe relating to your question, the way these definitions were formulated, it allows you to verify that one car is properly responding to the other, kind of pairwise. So when you can evaluate the behavior of the car, the self-driving algorithm, relative to the other car. They kind of call it a star-shaped computation, which makes it much more computationally efficient.
So does that mean that if the yellow car is responding to this pedestrian who suddenly crosses the road, that you don't have to take that into account because it is already incorporated in your anticipation of possible behavior of the yellow car?
So somehow they will have definition of properly responding to the car and properly responding to the pedestrian. There will not be a contradiction between them. As an example of a not good definition, they give, what if you still had this very simple scenario, but the yellow car was supposed to accelerate a little bit if the distance between the cars becomes too small? Well, then, imagine a third car before the yellow car. This might be imposing on the yellow car both the duty to brake and a duty to accelerate. This is not what they want. They want non-contradicting definitions of reasonable behavior towards every other car on the road separately. Okay? And also the formal proof of this, in this case it's really simple, but it becomes much more complicated. The formal proof is by induction, which is also something that they see as kind of helping scalability. This, as I mentioned, generalized to really complex scenarios, which they have in their paper, so multiple lanes, driving in both directions, junctions, and pedestrians, basically everything you can think about. To me, the most amazing thing is that it works. It seems to work in experiments. Maybe it's not as surprising, right? Because actually humans do drive and apply some standards of safety that work. And we're definitely computationally bounded and so on. Some other takeaways from this case study. So do you agree that proper response formalizes duty of care? Okay, this is definitely what they claim. It's not clear to me that this is actually what it's doing. Also, it's interesting to me that this duty of care definition does take into account computational tractability. And the last point is the choice of parameters, right? We mentioned these parameters of reasonable brake time, brake rate, acceleration rate, response time, and so on. These are really somehow encoding a trade-off between the competing values, right? Between being able to have useful transportation and safety. And kind of as something to keep in mind towards our third case study is that the parameters can be personalized almost. Okay, they can take into account whether the driver is human or robot, road conditions, and maybe even more. Okay, yes?
I'm not sure I completely followed. Does this mean that there can never be accidents, or does this mean that in the event of an accident, we would say that the cars have not engaged in negligent behavior?
Exactly. The second.
Yeah.
So everybody.
You can't stop, the car in front of you from exploding.
Right. So no, you
that car could explode.
But if you go back to the actual definition a few slides back,
right.
The definition here of safe distance, sort of incorporates some notion of what you would assume reasonable is as well. So it's hard for me to separate.
I think this is why it's the second thing that you said, right? So if other people are not behaving reasonably, there could be a crash. You would not be responsible.
So you would.
Okay? By definition, you're not responsible.
Okay.
I see that I'm.
So, I guess if I just reflect on my own driving algorithm, such as it is, there are some hard parameters here that there's all these numbers are going to depend on the vehicle that's in front of me.
All these numbers are, yes.
All these
right.
numbers are, row A, X, N.
Right.
Right, and there are types of vehicles like a sedan where I have like some sense of what those numbers are because they're maybe somewhat comparable to like me. But then if there's like a big truck or a tractor, I'll like treat it very differently. I'll just give it a lot more space because I just don't really understand what it's like.
Exactly. So you want your algorithm to be the same, or maybe if the algorithm could predict better, it's going to be more efficient, right? So I see I'm more or less out of time. So should I kind of wrap up?
There's been a lot of questions during the talk, so why don't you talk for another 3 minutes?
Okay. So let me show you in the level
the rest of the questions are held until after the discussion.
Let me mention at the level of kind of what the topic is. What the two other case studies I wanted to mention are. The first one is collusion by pricing algorithms. There's a really interesting paper that basically shows that if you let algorithmic pricing, you let algorithms learn how to price separately without communicating, they learn to collude. Where collusion is according to an economic definition of it. This would be a graph that shows it. And what I kind of wanted to say about this case study is that definitely we want to encode into the algorithms, into the learning pricing algorithms, a constraint of non-collusion without hindering their flexibility to be efficient too much. This is a really challenging problem. Actually, the current law just circumvents this entirely by forbidding only explicit collusions. Here the algorithms, as I said, they're not communicating when they learn to collude. So the current law doesn't seem to capture this. So it's an interesting example of where you might need to revise algorithms and law at the same time. Okay, and the third case study I wanted to show you is, up till now we kind of saw how algorithms might be getting closer to legal doctrines and encoding them in some sense. What about the other direction? Okay, so what if the law wanted to get closer to what an algorithm would look like, in particular have input? Okay, this has been studied under the title of personalized law, I think initiated in 2014. There are some compelling examples, which I won't go into. And I think the kind of vast experience we now have in computer science with personalization, its implications to fairness, to privacy, and so on, could be very relevant to this attempt of law. And ultimately, probably, if you do have a personalized law, it will probably be implemented as an algorithm. Okay. So we've reached the discussion. I think I'll finish by showing you this slide of what might be challenges to collaboration, and then kind of hear from Nicole and from you. So as we've been discussing, it seems that in some sense the approach of algorithm design and law is very different. The worst case approach could be too restrictive. This is one kind of question I wanted to raise. And on the other hand, the open-endedness of some laws could be too informal for us to capture using algorithms. I wanted to mention the work of Kobe that is attempting to bridge these gaps, and also of Niva about trying to extract rules from these open-ended laws. Well, sometimes we try to formalize the important things that we want the algorithms to achieve, and we just run into impossibility results. Okay, so you all know the incompatibility of natural fairness notions. There's a very recent paper of Kobe and Aloni that shows that if you take this notion of security and singling out, it doesn't really self-compose, which is something we would have expected. Okay, so these kind of impossibility results might stop advancements. The issue of mathematical modeling, which I've already mentioned, and then also auditing, which is a huge issue. And this is more or less it. Right, so we've seen how algorithms are currently kind of doing what used to be within the realm of law, balancing among values, and doing this kind of social engineering. Within CS, I think this opens up new avenues for research in algorithm design, and I'm going to show 2 examples of trying to formalize negligence and antitrust. And between CS and law, it seems there's big potential, but also big challenges. Okay.
So we're super lucky to have Nicole Ozer give us commentary on this. Nicole is the
What is Nicole right now?
Technology and Civil Liberties Director at the ACLU of California. So perfect to tell us what this talk is about.
Good morning, everyone. So really nice to be able to join you this morning and respond to Inbal's really important inquiry. Is it time for wider collaboration between computer scientists and particularly folks who are working on algorithms and the law? So spoiler alert, my response is resoundingly yes. It would be great to have sort of wider collaboration. But I have sort of 3 friendly amendments to what Inbal's sort of been talking about. And actually, many of you already touched on several of the things I was going to say. So I feel like I was on the right track, so that's good. So for a little bit of context about my approach before I discuss sort of the 3 friendly amendments, I am Nicole Ozer. Just a little bit of background. I was sort of on the leading edge of students here at Berkeley that were trained in public interest technology. I went to Berkeley Law in 2000 and graduated in 2003. I'm a lawyer, so obviously I come from that approach, so don't take it against me. And for the past 15 years, I have been leading the ACLU's intersectional work on technology and civil liberties here in California. So I've been involved in work in the courts, work in the legislature, work with companies, and also work with communities on the ground on issues that are affecting them. And particularly being embedded within the ACLU means that I've worked on really all of our cross-functional teams on intersections of technology and racial justice, immigrants' rights, reproductive justice, economic equality, sort of all the different issues that we're talking about, and Inbal really talked about that algorithms are really affecting so much in civil society. I am also on sabbatical right now, so I'm on sabbatical this spring from the ACLU, and I'm really fortunate to actually be visiting at Berkeley Law. And I'm also doing a non-residential fellowship this year at Stanford to be studying how to create better intersections, what are the opportunities and what are the challenges of creating more collaboration between people who are real experts on digital issues and individuals who are working on broader civil society issues. So this was an exciting proposal that sort of I read, and I'm really looking forward to sort of more collaboration. So my 3 friendly amendments really come from this perspective of the work that I've been doing for the last 15 years and what I'm currently studying on sabbatical. So first, yes, there should absolutely be a wider collaboration, but as Helen already said, absolutely I think that there should be a wider collaboration, not just between CS and algorithms and lawyers, but a wider collaboration between not only the academic sphere, between folks who are working on law and technology, but also all the social science, all the folks who are real experts on the issues of what's going to be affected by AI and algorithms, and broader than just the academic perspective. The issues that we're talking about really touch on all aspects of society, health, democracy, education, and I feel like we really need the wider input and collaboration of folks who really understand what the impact is on the ground, as well as in different academic disciplines. I'd have to say, as a lawyer, I know that a lot of our scholarship is actually relatively disconnected from what happens in the field and what happens in other disciplines. There are many good collaborative folks at many campuses, but generally I'm really looking to this collaboration to be beyond just the law and beyond just academia. I think if not, we really end up talking past each other, and we aren't building things that actually make sense from all those disciplines and actually make sense for what the impact is on the ground. My sort of second suggestion is that whatever proposals are put forward should really be built on many of the conversations that are already happening. So ACM that is being chaired by Pam and Danny. There have obviously been some joint courses that are in motion, but there's really a lot happening at institutions, and I think much of that has been siloed. Some of us know about things happening on one side, some of us know about things happening at the other. Deirdre's been organizing a really great project working group here on campus called AFOG, about algorithmic fairness and opacity working group. I think it's a great example of sort of trying to build across the disciplines. The AI Now Institute in New York has been doing really interesting research on this area. Peter Eckersley, who was formerly at EFF, is now the research director at the Partnership on AI and is looking at some really interesting intersectional work as well. And literally every week I get a call from another organization that's planning another event to talk about these issues. Like both Aspen and the Future of Humanity are doing events next week on this issue. So there's a lot moving. I think one of the most exciting opportunities, I think, just recently is last month it was announced that there's this new public interest technology university network, which is bringing together 21 institutions across the US. It's a partnership to really think about how to build and support more public interest technology and collaborative infrastructure. So it's at Berkeley, it's at Stanford, it's at Georgetown, it's at Howard, it's sort of around the country. And I think that hopefully that might actually provide some seed support for more of this collaborative work across institutions. The third sort of friendly amendment is I've been in a lot of general conversations where we never get to what are some of the more precise opportunities for us to collaborate across disciplines. And so to really think and do some hard work about where are some real places where we could actually get together and do really useful working groups. So broader than just privacy or autonomous vehicles, but really precise questions. I think that when we're approaching those precise questions, this was brought up earlier that, code is law. Law is also law. And law doesn't build itself. It doesn't auto-update. It doesn't cover many things. In order to create law, you actually have to have social movements and energy to actually change that law. And so to really think critically about what are the opportunities and what are the limitations of each discipline, and that we can't each necessarily get to where we want to go alone. We have to sort of think about what are the best we can pull from certain disciplines, where are things that we just can't address with certain disciplines, and come to that conversation really in sort of active listening and learning mode and not in persuasion mode, which is often very hard for those of us who are trained as lawyers, to not be persuading the other group that actually our mechanism or our mode is the way to really solve this problem, but to really actively listen and hear where are opportunities that we can pull from those different disciplines. Because I think when we're in that mode, we actually find that there's much more similarity than we might have anticipated. Just yesterday, Inbal and I were talking about this and about this presentation, and she talked to me about the worst case scenario in terms of building algorithms, which I was not aware of. And I thought that we had a really interesting conversation about how that worst case scenario mode is actually often how we also draft legislation. While it may be different in case law, when public interest lawyers are drafting legislation, we are looking for who are the most vulnerable. How could this fail and who could it affect? And so I think that actually we have some very common mechanisms and approaches when folks are drafting patents or drafting legislation. It actually is quite at least from our initial conversation, there is some similarity of narrative and language that we can learn to talk to each other rather than past each other. So my response is a resounding yes. I hope that it's broad, and I hope that I'll get to be helpful in whatever ways might be useful. So thank you.
Maybe we can have a couple of reactions and then have the rest of the discussion over coffee.
So just a few thoughts. I think one is that I think it's really when we look at these set of questions, and I think these case studies are really interesting, is to ask what is lost in translation when we are taking a duty of care that is a legal concept and we codify it, for instance. And I think that one has to do with, one of the things that comes to mind is the signaling or the normative power of a norm, right? And so, a duty of care that is formalized for autonomous cars is actually automating something, right? You sort of think of a machinery, like autonomous cars talking to one another. When we think about norms, we think about also the signal, the way in which autonomous agents need to direct their behavior. And so sometimes this is maybe the ex post ex ante view, and I think that going back to Solon's remark yesterday about what makes AI different, I think that when we don't have a justification for that, right? Autonomous agents need to have some idea of why it is that they need to behave this way or another, and sometimes when we look at these formulas, maybe this is good for autonomous cars and not that helpful for human beings.
You need to pick someone. Yeah, I guess I'll just go ahead, because I put my head down and it looked like I had a question. I don't know, whatever. It's the question I have is about how we will actually design things, because I can imagine that car companies may have an interest in designing duty of care in a way so that they're not legally liable, which is different from like interpreting the law as a kind of normative norm. Right? Like, and we see this in privacy engineering all the time. Privacy engineering is making sure you look compliant, but that doesn't mean you're protecting privacy. They're two different things. And so I'm wondering how we take into account the kind of interest of the companies to optimize for certain functions, including, for example, as little legal trouble as possible, which is like potentially the objective rather than the constraint at some point, and how we deal with that delta between those things. Or is anybody even thinking about like adversarial design of this sort? It's a question.
So I can say one word that I think at this point in time that they're trying to sell people on self-driving cars is maybe a point that they're really thinking about social welfare. Yeah.
Maybe is a like, okay. Maybe not, right?
Well, the question about whether there's legal liability is if there's actually statutory law that requires certain things and the enforcement is such that if it's not followed, there's liability. I mean, statutory law is very much about avoiding the harm rather than after the fact. Yes. So that's a huge difference. I think that perhaps there's sometimes a conflation between case law or constitutional law, which is after the harm, versus statutory law. When we're drafting statutory law, we are always looking at, let's avoid the problem and let's incentivize the companies not to create a situation which could cause harm.
But I thought the example number one, I don't remember now how we formulated, but Solon asked this question, like, is it to avoid the accident or is it to show that you had duty of care? For me, I'm not sure if that is avoiding harm in the sense of harm to the driver and the company, or if it's harm to the, like, by crashing to the other car and having damage.
And it depends how it's crafted.
Yes, but I thought that was like a really good example of how you could totally interpret that in adversarially, out of lack of a better word. Yeah.
Right.
Jamie.
Yeah, I just think a nice counterpoint is the question, so definitely stuff gets lost in translation when computer scientists try to formalize legal doctrine, even if they're talking to lawyers. But I think also, and especially in the self-driving car context, one thing we need to be really careful about is that our mathematical formulations also lose a lot of reality when writing down our formalisms. So like, I was trying to think about what was bothering me about this work that you presented, and I think the fact that like there's nothing works if there's like errors in estimation. And that's not to say that like that's a problem with what you presented. It's a problem of like somehow like this formalism ignoring the fact that it will be incorrect always. And maybe formal methods has something to say about this. I'm not a formal methods person, but I think it's really critical that we think about like what we can say when our models are wrong.
Robustness.
Yeah, it's not, yes, but not quite.
Not totally, yeah.
I'm not a formal methods person either, but I think the kind of aspects of this where you're capturing physical uncertainty about physical quantities, that's something that people have thought a lot about.
Yeah, of course.
Reasonably easy to nail down what that might mean. But I think your point, taken more broadly, very much still applies, which is like, somehow you need your system to be able to handle the disconnect between the abstraction and the way it's going to be applied. And it's like, by definition, it's sort of thinking about the abstraction, right?
Yeah.
So there's almost like a fundamental
impossibility
there.
Right. And
so
I think
you have to kind of be suitably humble about.
And computer scientists are notoriously good about being humble.
Oh yeah.
Lawyers and all is so good.
But can I just ask before you go on? You said that this has been covered, like the physical uncertainty in environments.
Control theory.
All right, got it.
Yeah, real-time systems,
yeah.
control theory, cyber physical systems.
Sure, lots of places, but machine learning sort of likes to ignore as much of that as possible when we can.
So, I just like this is very interesting to think about this in like a longer history of like the people we train to do this kind of work. Like, especially like what Nicole was saying, like there's this kind of established notion of a technologist that goes to work in the policy world, and that has traditionally meant like someone trained in like a traditional engineering field or maybe computer science who has expert knowledge that they then like communicate to policymakers and advocates so that they better understand the technology and then better know how to apply the existing laws, better know how to develop appropriate regulations or policies. That's like extremely different than what we've just been talking about, I think. Like I actually think like trying to develop the people to do this kind of work is a completely different process. Like we're not asking people to say like, here's the fundamentals of crypto and therefore this policy doesn't make sense. We're actually asking people to become like the engineers to encode normative values. And I really think the training that we would want for people to do that is very different than just simply saying like, your policy for security is ridiculous because it's completely detached from the reality of the technical process. And I worry a little bit too about how like the orientation we might take in figuring out how to train these new people is to like think about how like everything needs to be channeled into the formalisms of computer science when like I actually think that one of the most difficult tasks actually is to even like recognize what the problem is. And that requires like not computer science education. And so it's like to be able to discover and identify interesting things to work on, not just because they're computationally interesting, but because like they're relevant to the world and they reflect real normative problems. I don't really know how to do that kind of education well. Like I don't really know people who I would say embody like this remarkable mix of things. And so I really feel like the existing infrastructure we developed for public interest technologists is not really well suited to developing those types of people.
Yeah, I mean, I would, so having, as you know, I'm a lawyer by training, but I have had on my team both technologists as well as folks who were computer scientists and lawyers, and folks who have been computer scientists and social scientists together. And one of the things that I've been talking about this new university network is that when if you're just training technologists to then drop them into organizations, you're actually continuing to silo. Because what happens is that the folks who actually know all the substance, if it's 90% substantive and 10% technology, those folks will still send the tech work to the quote-unquote technologists because they feel intimidated by the technology. And so finding a way, rather than doing that, finding a way that we're actually creating collaborative interdisciplinary training at the academic level, so we are sending folks out into the world that actually see those issues and can communicate together from both sides. So technologists understanding the issues, as well as folks who are not technologists not being intimidated and being able to connect with the technology issues. That is my hope for this new initiative, and I've been talking to people about that because my experience has been that it is not useful to just put technologists into the field. It actually takes a lot of years, and I know 2 or 3 of them that have been very successful, but it's taken, Chris Segoyan, Chris Conley, a decade or more, Peter actually, till they can actually do that effectively. So we can talk more about it. But I'm optimistic and hopeful if we can do it right.
Let me propose that the rest of the discussion happens over coffee and bathroom breaks so that we have time to do both before we come back here in 15 minutes.